This is Budget Guns and Gear Reviews. Today we're going to talk a little bit about the Peruta case. For those of you who don't know, the Peruta case is a Second Amendment case that was before the Supreme Court. Well, they wanted it to go before the Supreme Court, and they refused to hear it today. What the Peruta case is it's Peruta versus California. The plaintiff in the case was suing because in California it's a May issue state as far as concealed carry goes, and the different counties in California interpret that very differently. In some counties in California, you just go, you do your application, you jump through whatever hoops they need you to jump through. The sheriff says, yep, okay, no problem, boom, there you go. In others, the sheriff wants to have what they call just cause, and it's basically just because they feel like it or just because they don't. You know, that it's really that simple. They want you to show good cause for it, and simply wanting to defend yourself isn't. So Peruta didn't like that. Filed suit, and when it reached the level of the Ninth Circuit Court of Appeals, the Ninth Circuit Court initially ruled in favor of Peruta, saying that that was a bunch of bull, and the state of California couldn't do that. However, the state of California appealed it, and it went before an en banc hearing for the Ninth Circuit, which is all the judges on the Ninth Circuit Court instead of the ones that originally heard the case, and then decided against it. So Peruta appealed it to the Supreme Court, who has refused to see it. They don't want to hear arguments on it and don't want to deal with it. Now, the anti-gunners are touting this as a great victory for their side, which on the surface it might seem like it is. Had the court ruled for Peruta, may issue would have probably went by the wayside as the law of the land, and it would have went to shall issue. There's a good chance of that happening. However, had it went the other way, may issue would have been the law of the land. This could have been a very significant landmark case with repercussions no matter how it had been ruled. But the court didn't hear it. So neither side is the law of the land. The law of the land is still shall issue some places, may issue in others. This may not be such a bad thing, given the composition of the court right now and things that are going to be coming up. Because Justice Kennedy is set to retire soon. And President Trump may have the opportunity to appoint another conservative justice. Kennedy was kind of a swing vote. He would vote with conservatives on some things, liberals on others. There was no guarantee that he would have voted in favor of Peruta. So by having this case turned down by the Supreme Court, there's a possibility in the future of another case coming up that would be settled favorably with a more conservative makeup on the court. So, yeah, you guys may have won the battle for now. But trust me, libs, this war is not over. And the battlefield looks like it might be getting a lot more favorable for the pro-gun side. I'm Mike, this is Budget Guns and Gear Reviews, and that was my 2 cents. Thanks. Keep coming back.